the beginning of the trial, I told you that you and I have separate functions. You decide all the disputed questions of fact, and it's my responsibility to provide the instructions of law. It's your sworn duty to accept the instructions as I have already given them to you, and as I will give them to you now. You're not permitted to change the law, nor are you permitted to apply your own concept of what you think the law should be. In the beginning of the trial, I told you about the roles that the attorneys were playing in this case. I talked to you about certain evidentiary matters that you are to consider. Now, I'm not going to repeat those instructions, but I do want you to bear those in mind where you're back in the jury room and deliberating on all of the factual issues of the case. Let me start my final instructions talking to you about the evidentiary concepts of direct and circumstantial evidence. Any fact in this or any other case for that matter may be proven by either direct or circumstantial evidence. Now, direct evidence is exactly what the name implies. That is, it is evidence which directly proves a fact without having to infer that fact from some other fact. Direct evidence is usually the testimony given by a witness who has seen or heard the facts to which he or she testified. And it will also include the exhibits that have been introduced into evidence. Circumstantial evidence, on the other hand, is proof of facts by direct evidence from which you may infer a fact in question. You're not required to make the inference, but if the facts support the inference, it is a permissible inference that can be drawn from the direct evidence. Now let me put you in a hypothetical case situation and explain a little further about the concept of direct and circumstantial evidence. Let's say in our hypothetical case, the question the jury is to decide is whether or not David ate the cherry pie. Let's say we have a witness come into that hypothetical courtroom and testify that she went in the kitchen and she saw David actually taking a piece of cherry pie and eating it. That would be direct evidence of the fact that David ate the cherry pie. The witness saw David eat the cherry pie. The witness testified to that. You don't have to make any inferences to get to the ultimate question you're trying to reach. Did he or did he not eat the cherry pie? Now let's say we have another witness come into that hypothetical courtroom and testify that he went into the kitchen and he saw David standing in the middle of the kitchen with an empty pie tin in his hand and cherry pie all over his face and all over his hands. That would be circumstantial evidence of the fact that David ate that cherry pie. The second witness did not see David eat the cherry pie the way the first witness did. The second witness saw direct evidence, the empty pie tin and the cherry pie in his face and hands, from which a jury could infer that David ate the cherry pie. So direct evidence plus the inference equals circumstantial evidence. Now the law makes no distinction between direct and circumstantial evidence as to the degree of proof required. And facts may be proven by either type of evidence or combination of them. Each is accepted as a reasonable method of proof, and each is respected for such convincing force as it may carry. One other thing about circumstantial evidence. You are permitted to draw more than one inference from the same set of facts. Now, let me go back to our hypothetical. Let's say in the kitchen there is David and his sister, and there's an empty pie tin in between them, and David's got cherry pie in his hands, and his sister's got cherry pie in her face. A jury could infer from that direct evidence that either David ate the cherry pie, his sister ate the cherry pie, or they both ate the cherry pie. That's more than one inference from the same set of facts. That's permitted. What is not permitted is take direct evidence, draw an inference to get to circumstantial evidence, and then without any further evidence, draw another inference on top of that inference. So an inference upon an inference is not permitted, but more than one inference is permitted. As jurors, you have the sole and the exclusive duty to decide and determine the credibility of the witnesses who have testified in this case, which simply means that it is you who must decide whether to believe or whether to disbelieve a particular witness, and how much weight, if any, to give to the testimony of each witness. In deciding these questions of credibility, you will apply the tests of truthfulness that you apply in your own daily lives. These tests will include the appearance of each witness on the witness stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which they've testified, the witness's accuracy of memory, their frankness or their lack of it, their intelligence, their interest, and their bias, if any. Together with all the facts and circumstances surrounding the testimony, you will apply these tests, and you will assign to the testimony of each witness such weight as you deem proper. Now, you're not required to believe the testimony of a witness simply because it was given under oath, and you may believe all, part, or none of the witnesses who have testified. Now, do not decide any issue of fact merely on the basis of the number of witnesses who have testified on that issue. Rather, the final test in judging evidence should be the force and the weight of the evidence regardless of the number of witnesses on each side of the issue. Remember, the testimony of one witness that is believed by you is sufficient to prove any fact. Now, if we had any discrepancies in a witness's testimony or between his or her testimony and that of others, that does not necessarily mean that you should disbelieve that witness, as people will commonly forget facts, or they may recollect them erroneously after the passage of time. And I'm sure you're certainly all aware of the fact that two people who were witnesses to an incident may often see or hear that incident somewhat differently. When you're deciding about a discrepancy in a witness's testimony, you should decide whether such discrepancy concerns an important fact or a trivial fact. You are the sole judges of the facts, the credibility, and the weight to be given to the testimony and the credibility of the witnesses. Now, the case before us began with the issuance of an indictment. An indictment informs the defendant that he's been charged with the crimes that are set forth in that indictment. The defendant, as he sits here, is presumed innocent, and that presumption of innocence stays with the defendant at all times. And that presumption is lifted only when and if the state of Ohio proves his guilt beyond a reasonable doubt on each and every one of the elements of the offense or the offenses. Reasonable doubt. Reasonable doubt is present when, after you've carefully considered and compared all of the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything related to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act on it in the most important of his or her own affairs. Now, the indictment originally charged 3 offenses. One of the offenses dealt with an allegation that the defendant entered an occupied structure. I made a determination as a matter of law that this structure, even though it could have been occupied at some point in time, was not an occupied structure as the law defines that. So I made the legal determination to dismiss that count. So you're left with 2 counts. And 1 count of breaking and entering and 1 count of theft. And what I will do, I will go through those terms with you with respect to each count. The defendant is charged with breaking and entering. Before you can find him guilty, you must find the state has proved beyond a reasonable doubt that on or about April 4th, 2014, in Ottawa County, Ohio, that the defendant, by force, stealth, or deception, trespassed in an unoccupied structure with the purpose to commit therein a theft offense. Force means any violence, compulsion, effort, or constraint exerted or used by any means upon or against a person or thing to gain entrance. Stealth means any secret or sly act to avoid discovery and to gain entrance into or to remain within a structure of another without permission. Deception means knowingly deceiving another or causing another to be deceived by any false or misleading representation, by withholding information, by preventing another from acquiring information, or by any other conduct, act, or omission that creates, confirms, or perpetuates a false impression in another, including a false impression as to law, value, state of mind, or other objective or subjective fact. Trespass means that the defendant, without privilege to do so, either knowingly entered or remained on the land or premises of Helen Steins, or knowingly entered or remained on the land or premises of Ms. Steins, the use of which is lawfully restricted to certain persons, purposes, modes, or hours, when the offender knew the offender is in violation of any such restriction or is reckless in that regard. Knowingly. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result or will probably be of a certain nature. A person has knowledge of facts and circumstances when he is aware that such circumstances probably exist. Now, since you cannot look into the mind of another, knowledge is determined by all the facts and circumstances in evidence. Land or premises includes any land, building, structure, or place belonging to, controlled by, or in the custody of another, including a public agency or any separate enclosure or room or portion thereof. Theft. I said they had to have purpose to commit a theft offense. Theft means that the defendant, with purpose to deprive the owner of property, he knowingly obtained or exerted control over the property, either without the consent of the owner or person authorized to give consent, or beyond the scope of the express or implied consent of the owner or person authorized to give consent. Purpose. A person acts purposely when it is the person's specific intention to cause a certain result, or when the gist of the offense is a prohibition against conduct of a certain nature, regardless of what the offender intends to accomplish thereby. It is the offender's specific intention to engage in conduct of that nature. Deprive. Deprive means one of the three following. 1, withhold property of another permanently or for a period that appropriates a substantial portion of its value or use, or with purpose to restore it only upon the payment of a reward or other consideration. Or to dispose of property so as to make it unlikely that the owner will recover it. Or accept, use, or appropriate money, property, or services with purpose not to give proper consideration in return for the money, property, or services, and without reasonable justification or excuse for not giving proper consideration. Owner means, unless the context requires a different meaning, any person other than the actor who is the owner of, who has possession or control of, or who has any license or interest in property or services, even though the ownership, possession, control, license, or interest is unlawful. Property means any property, real or personal. Consent. Consent may be either express or implied. Express consent is determined by the written or spoken words of the persons involved. Implied consent is determined by the facts and circumstances that surround those involved, including their words and acts, from which you may infer that consent was given to the defendant. I use the term without privilege to do so. Privilege means any immunity, license, or right conferred by law, bestowed by express or implied grant, or rising out of status, position, office, or relationship, or growing out of necessity. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of breaking and entering, your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any of the essential elements of the offense of breaking and entering, your verdict must be not guilty. Now, you must first consider the offense of breaking and entering. If you find that the state proved beyond a reasonable doubt all the essential elements of breaking and entering, and as I said, your verdict must be guilty as of that charge. However, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of breaking and entering, then your verdict must be not guilty of that offense, and in that event, you will continue your deliberations to decide whether the state has proved beyond a reasonable doubt all the essential elements of the inferior offense of criminal trespass. If the evidence warrants it, you may find the defendant guilty of an offense lesser than that charged in the indictment. However, notwithstanding that right, it is your duty to accept the law as given to you, and if the facts in the law warrant a conviction of the original offense charged in the indictment, then it's your duty to make your findings uninfluenced by your power to find an inferior offense. So the initial offense is breaking and entering. If the state hasn't proved one or more of the elements, then you are to consider the lesser included or inferior offense of trespass. Now the definition of criminal trespass, before you can find the defendant guilty of criminal trespass, you must find that the state proved beyond a reasonable doubt that on or about the 4th day of April 2014 in Ottawa County, Ohio, that the defendant, without privilege to do so, knowingly entered or remained on the land of another of Helen Stein's. And with respect to the other elements of trespass, I've already defined those to you, because I defined those to you in the offense of breaking and entering. And if you find the state proved beyond a reasonable doubt all the elements of the offense of trespass, you must find him guilty of that lesser included offense. If you find the state failed to prove his guilt beyond a reasonable doubt in the offense of trespass, you're to find him not guilty. Theft. The defendant is charged with theft, and the count 3. The B&E is count 2, and this is count 3. The defendant is charged with theft. Before you can find him guilty, you must find the state proved beyond a reasonable doubt that on or about the 4th day of April of 2014 in Ottawa County, Ohio, that the defendant, with purpose to deprive the owner of property, knowingly obtained or exerted control over that property without the consent of the owner, who's Ms. Steins, or a person authorized to give consent. It is further alleged in that count that the victim, Ms. Steins, was an elderly person. Now, I've already defined for you all the elements of theft, and I've defined for you the breaking and entering. If your verdict is guilty, you will find beyond a reasonable doubt whether the victim, in this case, was an elderly person. An elderly person is one who is 65 years or older. That's pretty young, but the state of Ohio defines that as an elderly person, so that's what you're bound by, because I'm older than that. And I'm not an elderly person. All right, if you find the state has proved that the defendant is guilty of theft, you must so find that and return your verdict of guilty of theft. If you find the state has not proved that beyond a reasonable doubt, then your verdict shall be not guilty of that. In deciding this case, you must not be influenced by any consideration of sympathy or prejudice. It's your duty to carefully weigh all of the evidence. You're to decide the disputed questions of fact. You're to apply the instructions of the courts to your findings, and you render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence. Use your common sense and make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so the state of Ohio and the defendant will feel that this case was fairly and impartially tried. If during the course of the trial you've inadvertently heard any comments outside of the courtroom, or you've rendered any opinions as to how you think I feel with respect to the factual matters, I'm going to ask you to disregard that. I don't wish to infringe upon your responsibility to decide the disputed questions of fact, as you have not infringed upon my responsibility to provide the instructions of law. Your initial conduct upon entering the jury room will be a matter of importance. It's not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change an opinion, even if you would find at a later point in time that that opinion was wrong. You should consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide the case for yourself, but you should do so only after a discussion and a consideration with your fellow jurors. Now, do not hesitate to change an opinion or position if you would later find that that opinion or position was wrong. However, Do not surrender honest convictions in order to be congenial or to reach a verdict solely based upon the opinions of your fellow jurors. Now, in the jury room, you are going to have the exhibits that have been introduced into evidence. Don't ask me for something that you don't have. If you heard some testimony dealing with an exhibit and you don't have that exhibit, don't ask for it, because there's a reason why it wasn't given to you. In addition to the exhibits, you're going to have verdict forms that you're to use in consideration of this case. This being a criminal case, before it can be said that you've reached an agreement, all 12 jurors must unanimously agree on what the appropriate verdict is. When you have made that determination, select the appropriate verdict form, fill out the verdict form, and when you've filled out the verdict forms completely, then you can notify us and tell us that you have reached your verdict. I will read to you the verdict forms. The first one I have is: we, the jury, find the defendant, Stephen Kraus, and there's a blank, of break-in entering. And it says, insert name, guilty or not guilty. So you insert the appropriate finding you make, and then you have a place for all of you to sign the verdict form. The next one is: we, the jury, find the defendant, Stephen Kraus, not guilty of the offense of break-in entering, but, and then it's guilty or not guilty, of the offense of criminal trespass. That's the lesser included offense of break-in entering. And then the third verdict form says: we, the jury, find the defendant, Stephen Kraus, and that's inserting guilty or not guilty, of theft. And then it says, if your verdict is guilty, then you have to further find: we, the jury, find that the defendant, we find the defendant guilty, further find beyond a reasonable doubt that the victim of the offense, and then it's was or was not an elderly person. As I said, once you have filled out the verdict forms, notify us, and we'll bring you back in the courtroom, and we'll have the verdicts read in open court by our bailiff, stash / attorney, assistants, firsthand. She does that. Most courtrooms kind of have a bailiff, but Ottawa County can't afford a bailiff and a staff attorney, so we have a staff attorney acting as a bailiff. But she'll read the verdicts in open court for us. I'm not going to tell you how to conduct your deliberations, other than to suggest to you that the first thing you do is select a foreperson, somebody to help guide the deliberation process. After you've done that, you can conduct your deliberations any way you so desire. And I do want to tell you that one thing you're not to discuss is the subject of punishment. In the event that you would find the defendant guilty of any one of the charges, the duty is placed upon me to make the appropriate determination of what that punishment should be, so don't make that part of your discussion or your consideration. I do want you to remember that you're a collective body of 12 people, and if all 12 people are not physically in the room when you're discussing things, somebody's not back from lunch or somebody is in the restroom, stop your deliberations and wait until all 12 people are back there. Other than that, as I said, you can conduct your deliberations any way you so desire. Let's go ahead and start your deliberations and break about 12 o'clock for lunch. You can take as much as you want. Are you getting lunch?
Well, if they stay in for lunch, we'll buy it for them. If they want to go out, they can do that on their own.
Boy, that's not a tough choice.
What do you provide?
The county will buy your lunch for you.
Sloopy's, we usually pick something from Sloopy's.
So I have to pay for mine, but they get.
We'll let you pay for yours.
That's all right. All right, well, you all decide what you want to do. If everybody's staying in for lunch, then you can conduct your deliberations while you're having lunch if you want to or not. Now, I will ask, first of all, let me ask the attorney, is there any additions, corrections, or deletions to the charge?
No, Your Honor. Nothing from the defendant.
Okay, it appears that the charge is in order. Who are alternate jurors? I know you're sitting out there. Are you the two alternates?
We are now. Yes.
You are now.
We were just advised of that.
Oh, you weren't?
I'm not sure.
No,
Were we
you're
or
not.
not? I don't know.
Who's got the list?
I have it here.
Actually, a good thing not telling you if you're the alternate, because it's just like, I didn't tell you that I'm going to give you these instructions in writing. See, if I told you that, you wouldn't have paid any attention to anything I said. So I'm going to give you reasonable doubt, and I'm going to give you all the definitions that are contained in the offenses. I'm not going to give you the circumstantial evidence. I'm not going to tell you any more about David. David, when I first started doing this stuff, was a little kid and he liked cherry pie. Now he's an orthopedic surgeon and he's 35 years old. He doesn't like cherry pie anymore. I still use David, my example, and his sister is also in it.
Madam President,
Yeah, thank you. Oh, okay.
yes.
Oh, okay, Ms. Szabo, is that correct? Who's Ms. Szabo? You're one of the alternates. Okay, and Mr. Guthrie? Going to kind of hold on to you. I understand they have a room with a TV and you can watch TV and you can listen to news. But, you know, she'll take you down there. And while you're down there, you're not to have any discussion amongst yourselves, the two of you, about the case. In the event that somebody, you know, would get ill or for some reason we'd have to go over to another day and somebody couldn't come back, an alternate can step in. We'd have to deal with that when it happens, and I would have another instruction dealing with how you start your deliberation process. But you're going to be separated from the 12 at this point in time. And the rest of the 12, anybody not able to conduct their deliberations at this point? Okay. Well, thank you all very much. We appreciate all the help you've given us, and go ahead and step back on the